Mr. Birch, can I just ask you, to what extent is the administrative appeal scheme relevant to the first step of this inquiry? What I'm a little worried about is that your argument seems to be conflating what had traditionally been understood and what we reaffirmed in Tlefsky as two different steps of the analysis in 1983. And the first relates to what extent is this provision unambiguously rights-creating? And then the second step asks whether Congress has created some sort of alternative remedy, or what is the enforcement scheme such that we might believe that 1983 is not available. So can you just help me to understand whether you're now suggesting that we evaluate whether this is rights-creating, as we talked about, in the first step, relative to an understanding of what Congress has done with respect to enforcement?
To be clear, Justice Jackson, we are not making a Step 2 C clamors argument. Never have, are not making it here. But as this Court made clear in Gonzaga, that the remedies available can buttress the interpretation of whether there is clear rights-creating language in Step 1. And that's what you said in the Souter decision in footnote 11 as well. And so we're using the provider's remedy and the lack of any beneficiary remedy to be able to challenge a provider's disqualification.
Confusing. I mean, there isn't a whole lot of indication that lower courts are confused about this. I looked very carefully at Judge Wilkinson's opinion. He lays out very clearly how this works and what we've said repeatedly. And I guess my concern is that the kinds of things, and I appreciate you had a long list of reasons why you think this isn't rights-creating, but one of them had to do with the nature of this, the enforcement mechanism, and I just see that as a Step 2 concern, and I'm worried about us getting people confused if we start putting those considerations into the first analysis.
Well, I think the analysis is distinct. If you're making a Step 2 analysis, the argument is that the remedies are so comprehensive that it bars the ability to go to federal court. In Step 1, just like in Gonzaga, just like in Souter, the court is entitled to consider remedies like the fact that the disqualified provider has an administrative appeal to determine whether there is a right to go to court. And I would note that one of the reasons it's significant Congress gave that administrative appeal to the disqualified provider and not to the beneficiary is because the provider is the one who has all the information. Under respondents' theory, if a provider commits malpractice and they're disqualified for that reason, there's still a beneficiary right to go to federal court and bring a 1983 action. And that makes no sense, because what does a beneficiary know about a provider's medical malpractice involving other patients?
Can I just turn your attention back to what I understand to be the classic kind of Step 1 inquiry here?
Yes.
And get us back to Justice Kagan's point about the state being aware of an obligation to do this. And I note that although you suggest that it would be easier if the word right was in the statute, in this particular statute, 1983 itself talks about rights, privileges, and immunities. So even if we were to have a magic words test, it seems to me to be too narrow to just say that Congress has to say rights, because we have in the 1983 concept, in the actual text of the statute, rights, privileges, and immunities secured by the Constitution and laws. So with an understanding of what 1983 was about, can you speak to why an obligation of this nature that runs to an individual in the way that Justice Kagan described doesn't get us sort of in the realm of rights, privileges, and obligations secured by the law?
Yeah, two thoughts on that, Justice Jackson.
Yes.
First, we're not limiting this to right. As I mentioned earlier, entitlement, privilege, I would even spot you immunity, because that's in Section 1983. I think any of those have the same rights-creating pedigree. But it is a high bar. An obligation is not enough. Telling a state that it has an obligation to do something or that it must provide something isn't the same as saying you have the ability to sue them in federal court and have 1983 fee-shifting opportunities.
Well,